I was about to text you if you can.
Why is that voice very? I have PTSD when I hear this voice. I'm very disconcerted.
You and me both, Your Honor.
Well, there we go. At least we're in agreement.
Hey, it was the personal. I had to beat your ass in jail. 302.
LA Jackson Myers.
Always a pleasure.
Give me leftovers. Is that what you're saying?
I just gave you popcorn. Be grateful. I have 3 popcorn. Hey, we've got 1/3 of my food.
First ever podcast.
That should be right.
Do you have water?
I do not have water. There's a vending machine outside though. We can get some.
It's my first like this.
I think I've killed every single cop in this room.
Not me, mate.
Not Hardy Stoppy, not that recruit.
If you kill Hardy Stoppy, I will make sure that you receive the death penalty in the city.
Killed Alex Murphy.
Yeah, don't you dare.
I want to kill you, Hardy.
I hope not.
I haven't killed Kate. I don't know.
Don't you touch Kate.
Oi, that's my lawyer. Yo, Jai, what's up?
Hello.
Everyone, can I have your quick attention at the moment? What we'll be doing very shortly. Oh, for fuck. Oh.
Nice.
What's happening?
We're taking it against the umpire.
Oh.
Alright. I need to turn off my work phone. Give me a sec.
It's gonna be one you don't want to miss.
I want to come in from that side.
Give me my credit cards.
Franco. Can I sit up there, my lad?
No, you don't have authority, so no.
Actual.
Alright. We'll do take 2 of this. Ladies and gentlemen, good evening. Welcome to this court case. My name is...
Can you speak up, please?
Take 3.
The dubs are sharp.
You guys have a seat.
Give me a second. I'll be back with you in 1 minute.
If you guys are planning on staying, can we please have everyone seated?
Shut up.
And sit up and not lay down.
Hey, something it out.
Lucky, if you're going to be disrespectful, mate, I'll take you out myself, okay?
I'm sitting.
In a correct chair, please. We don't accept
Get up,
lawn
mate.
chairs.
It's gonna be removed.
Why
Stop
don't
fucking
launch
around,
it?
man, and sit down. Fucking hell.
Take a seat, guys. Fuck, how hard is it?
Excuse me, Mr. Red Dreads.
You're gonna be a sick cunt. You're gonna get arrested. You're under arrest.
No way someone's already arrested before the start of the trial.
Hey, Thomas Silver.
Alright, just give me another 30 seconds. We'll just finish this up.
He's giving me my job at Melbourne.
Are you one of the witnesses? Excuse me? Are you one of the witnesses by any chance? You're not, okay. Wait, are you the witness? One of the witnesses? Okay. And then you're witness number 1 here, correct? Miss Silver?
Yes.
Is this witness 1 here that's witness 2 there?
I am witness to
Okay.
Yes.
And that is witness 1, correct?
That's correct.
Perfect.
Bye. Tell Hardy stop here. I said bye.
Goodbye, Lucky.
Tell Kate I said bye also.
Alright, take 3. What we'll do is we'll now have the doors locked at this time.
Could you speak up, please?
My apologies, give me a second.
I'm gonna tell your friends, their family, to move onto this side so they're not supporting the police. Jungle?
Just shout your voice, that might be better.
Jungle.
Alright, is this better, everyone? Can you all hear me?
Yes.
Perfect.
Yes.
Good evening, ladies and gentlemen. My name is the Honourable Justice Jackson Mars with the Supreme Court. Today, with a very rare case, being both a civil trial and a criminal appeal of one Mr. Jungle MCL versus the Crown. I will be commencing relatively shortly. However, just a quick notice to members of the gallery. You all know how this works. Any interjections by any one of you, immediate contempt of court, 100 weeks, $1 million fine. And I'll have probably no choice but to eject everyone out of this court case only because it is a very complex court case this evening. When you are interjecting and acting like a fool, it does not just hinder the prosecution's case, it also hinders the defense's case. So again, respect goes both ways. If you respect the court will respect you. This is a pretty general principle. Also, to the individual in the back left-hand side of this courtroom, any use of telecommunications will also get you kicked out. I'm hopefully very clear on that front. Besides that, we'll commence as of now. Is the plaintiffs ready to commence?
We are, Your Honor.
And to the defense, are you ready?
We are, Your Honor.
Very well. Excuse me, sorry.
Sorry, sir.
Oh. And court will be in session on Saturday, the 9th of August, 2025, at 2000 hours and 7 minutes past the hour. In the case of Jungle MCL v. The Crown, can the plaintiffs please come forth? Before we begin, can you please state your full name for the record?
Jai Foster.
Very well, Mr. Foster, please take your seat. Can the defense please come forward? Before we begin, can you please state your full name in addition to the name of your co-counsel for the court?
Mark Jackson and Hudson Sculber.
Very well. You may take a seat. Just give me one moment. Very well, we'll now begin with opening statements. If the plaintiffs can please come forward and deliver your opening statement in relation to your appeal, in addition to your civil case of the court.
Thank you, Your Honor, and good evening to yourself and members of the court. Today, the plaintiff intends to strongly dispute the criminal charge of dangerous driving without causing injury, which is accused against my client, Mr. Jungle MCL. I urge the court this evening to listen to all evidence in full and in depth, not just from the plaintiff, but also the defense. We stress the requirement that in this case, it is not to be assessed on opinions, assumptions, but facts. And we also, as a result, plead that the legal threshold be met with this matter. The burden of proof with this matter lies with us, the plaintiff, and we are required to establish beyond reasonable doubt and in the balance of probabilities that my client, Mr. MCL, on the 10th of July, drove in such a manner that it created a real, significant, and substantial risk to other road users. Being in a vehicle collision does simply not equate to driving in a dangerous manner. I will demonstrate to the court that my client drove in a competent manner and that no driver could have reasonably seen an unmarked, silent approaching police vehicle at 238 kilometers per hour, seemingly driving where a collision and serious injury was imminent due to a blind spot and a crest of a hill. My client could not reasonably expect for an unmarked police vehicle with no audible warning traveling at 4 times the speed limit be approaching him. I will repeat that, Your Honor. 4 times the speed limit. The law applies to every single road user, not just the general members of the public, but also police. The law requires vehicles to be operated in such a manner that it does not endanger others. The police members who were traveling at 4 times the speed limit involved in this collision simply failed their duty of care and failed their obligation of abiding by the law. This collision was not caused by deliberate disregard for others' safety by my client, but by dangerous driving by police who failed to slow down to clear 2 intersections, both which used traffic lights and were both red, and failed to slow down, approaching a serious and almost deadly blind spot. Like one of the many arresting officers said that night, wouldn't you rather get there safely in one piece? A hypocritical statement which does not reflect their driving standard, attempting to hand pass the blame to my client. The prosecution will further demonstrate the arrest, search, and subsequent seizure of personal property of Mr. MCL's were procedurally flawed, and whilst not at the core of today's charge, they cast doubt on the reliability, objectivity, and conduct of the arresting members. We ask the court to find that the charge of dangerous driving is found not guilty and that reasonable doubt does prevail. Thank you, Your Honour.
Very well. We'll now have the defence please come forward and deliver your opening statement in relation to the criminal appeal in addition to the civil case presented by the plaintiffs.
Your Honour, members of the court, today we are here to address two critical matters. A criminal appeal brought forth by, brought forth by the plaintiff, Jungle MCL, and a civil proceeding concerning the lawful seizure of funds discovered during a traffic stop. Beginning with the facts, on the day in question, Mr. MCL was dangerously driving. He pulled out into traffic without due care, without indicating, without hanging up his phone call, swerving directly in front of a police vehicle that had its emergency lights activated and traveling at high speed. This careless act caused a collision between the police vehicle and Mr. MCL's vehicle. Due to this dangerous act, a traffic stop was initiated. During the stop, Mr. MCL was questioned about his dangerous driving. He gave no valid or reasonable answer to these questions, leading to officers placing him in custody. Upon a search of his person, officers found a large amount of cash, exactly $807,041, as well as a range of illegal and suspicious equipment, including 21 lockpicks, 8 electronic lockpicks, two electronic devices. This is opening.
Mr. Foster, there will be no objections during opening statements in addition to closing statements. My apologies, you may continue, Mr. Jackson.
2 electronic devices, an angle grinder, and more. The large amount of digital tools, physical tools, and unaccounted cash gave officers reasonable suspicion to believe that the funds were tied to illegal activity, leading to the lawful seizure of those funds. Today, the prosecution will demonstrate. Today, the defense will demonstrate that both the arrest and search were lawful and that the seizure of funds was an appropriate response to the overwhelming indicators of illegal activity. Thank you.
Very well. We'll move on to witnesses. Now, just a reminder, Ms. MCL, although you're not named in a witness list, given the fact that you are on the plaintiff, if you are on the name for this case, you can be still brought up to the court by your counsel or even by the defence's counsel. Witnesses, their questioning shall pertain to all matters, just so we don't need to repeatedly bring people back up to the stand after they've finished. So to the plaintiffs, you may begin by calling your first witness in relation to this matter.
Thank you, Ron. I would like to ask for witness 2 to the stand, please.
Is that 184 Bravo, out of curiosity?
Like the legal discussion we had, we were unable to identify it. It is the female with the white hair standing on the right-hand side.
Very well. I'll ask the individual to please come with me to my chambers for ID verification. Just in here. I'm just on whisper. Just need you to flex your badge for me, just for the records. You will not be addressed to the court by your name. Kate Bellucci Foster. You'll be 184 Bravo for the purpose of this case.
Okay.
All right. Just Please take a seat. Are you perchance a religious individual?
No.
Very well. Miss 184 Bravo, do you swear that the evidence you're about to give shall be the truth, the whole truth, and nothing but the truth, and the threat of perjury, which is an indictable offence in the city of Melbourne, which commands 100 weeks and $1 million fine? Do you swear?
I swear.
Very well. To the plaintiffs, you have the floor.
Thank you, Your Honour. So Miss 184 Bravo. So on the night of the incident, what seat in the vehicle were you seated in?
I believe I was in the passenger seat of the vehicle.
Do you believe or do you know?
I cannot 100% confirm.
Is there
I
a
do not
reason why
recall.
you don't think? Well, is there a reason why you can't recall where you were seated?
It was almost a month ago, so I'm not.
Okay. During the incident, did you have a clear view of the speedometer at any time?
I affirm.
You did. Okay. And what speed was the vehicle traveling at in the build up to the crash?
I do not recall.
You don't recall. Do you remember where you had started driving from before? So before the crash, did you before you got onto Popular Street, what road did you turn off of to get onto Popular Street?
Objection relevance.
To the plaintiffs, do you have any reasoning as to why this may be relevant to your case?
It is relevant, Your Honour, because it does speak for the speed and how quick Melbourne Police, well, the driver was able to get to the speed of 238 kilometers per hour in the build up to the crash. I'm trying to simply determine if they had entered on Vespucci Boulevard or if they'd started further up on Harwick Avenue.
I will allow the question.
We were coming from VPC 900.
So was that Harwick Avenue or was that Vespucci Boulevard?
I do not recall the street name.
So had you been on Popular Street for? Did you turn right onto Popular Street and you're on Popular Street for a few seconds, or were you on Popular Street for maybe 20 seconds or so before the collision?
I do not recall.
Don't recall. Okay. Before the collision, the first set of lights at the intersection of Popular Street and Vespucci Boulevard, do you recall what color the light was and what speed you were traveling at?
Objection collateral is going to introduce way too much. Just a massive can of worms, Your Honour.
A
What?
massive can of worms in what regard, Mr. Jackson?
Officers are exempt from the Traffic Act of 2025. I don't see how a light has any relevance to this case.
If I may, Your Honor.
Mm-hmm.
I'm just simply trying to understand the speed that they were traveling at, including the light color. If it was a green light, a higher speed simply is permitted. However, if it's a red light, police have the legal obligation to slow down and properly clear that intersection before continuing for the safety of the public and themselves.
I will warn you, Mr. Foster, you are starting to skid on very thin ice, but I will allow this question.
I do not recall the color of the light.
All the speed?
Oh, or the speed, no.
Is that the same for the second and third satellites as well?
Yeah, I do not recall.
Do you know if the driver at all slowed down at these lights at all?
I don't recall.
Don't recall. Okay. And at any point were sirens on the police vehicle activated?
I don't recall.
Where the collision happened, there is a crest near the location. Is that correct?
Sorry, can you repeat that question?
So where the collision happened, there is a crest prior to the location, correct?
Uh, I don't recall.
Don't recall. Okay. So you don't think there's a hill at all from in any proximity to the location where the crash occurred?
Off the top of my head, I don't recall the exact geographics of that road.
Do you think that it's possible in 2 seconds for a driver to pull off from the side of the road and then turn into traffic in 2 seconds? So let me reword the question. Sorry. Do you think it's reasonable that a driver that checks their blind spots, that they check their blind spots and move off from the side of the curb within 2 seconds into traffic? Do you think that's a reasonable time? Or do you think there's a larger time required between
Objection
them?
compound.
I will sustain the objection by the prosecution. I'll ask you to break up these questions one by one.
So can I reword that question, Your Honor?
Yes.
Okay. Miss 184 Bravo, how long do you think it takes between somebody checking their blind spots and moving off the curb?
Objection speculation. You're asking witness to think.
Sustained by the prosecution. Sustained in general. I'll ask the plaintiffs to reword or move along.
I'll move on, Your Honor.
Very well.
Miss 184 Bravo, during at the time of the collision, you were heard stating, well, that is unfortunate. What did you mean by that statement?
Objection lack of foundation.
If I may, Your Honor.
Mm-hmm.
It speaks for what the officer thought at the time of the driving, and if she had deemed it to be dangerous driving, because from what she had said, oh, that is unfortunate, seems to be a big accident and an accidental collision of vehicles, and not a matter of dangerous driving.
I will allow this line of questioning, but I need yet to remind you that you're very much skating on some very thin ice.
Miss 184?
I do not recall.
Okay. Do you remember anything from the incident at all?
Sorry, can you repeat what you said?
Do you understand? Do you recall anything from the incident at all?
I do recall the incident itself, just not the finer details in said incident.
And where were you heading to at the time of the incident, if you can recall?
Objection relevance, Your Honor.
Your Honor, it speaks for the speed that required to attend. I'm simply trying to determine if the driving was the speed that the members were traveling at was required, because if they were simply heading to a very low risk hole, it simply does not justify them traveling at 238 kilometers per hour in a 60 kilometer per hour zone. Now, if they were attending an urgent job requiring urgent duty driving, it does justify almost in some way, but still does not justify that they were permitted to drive at 238 kilometers per hour.
I don't see the relevance of the type of call out to be indeed relevant to this matter. I will sustain the objection. I'll ask you to move along.
And Miss, final question. What was your only basis for dangerous driving was your own view, correct?
Can you reword the question for me, please?
So your basis for saying or stating that it was dangerous driving, was that your personal view? And what, in your opinion, did you use to determine it was dangerous?
I do not recall my thought process during the incident.
Have you reviewed the body cam footage at all since the incident?
Yes.
So what from the incident did you determine to be dangerous from my client? Your Honor?
I am not sure how to answer that question.
So you're not sure how to answer what you deem dangerous.
I will suspend this witness testimony at the moment, given the fact that the other witness is under severe time constraint at the moment. We'll call this witness back up relatively shortly. But for now, Ms. 184 Bravo, please take a seat. If Mr. 184 can please come to my right. Are you perchance a religious individual, sir?
Negative.
Please take a seat. Mr. 184, do you swear that the evidence you're about to give should be the truth, the whole truth, and nothing but the truth, under the threat of perjury, which is an indictable offence to the City of Melbourne, which carries $1 million fine, 100 weeks in jail? Do you swear?
I swear.
To Mr. Foster, you may continue.
Mr. 184, do you have any recollection of the incidents that occurred on the 10th of July?
I have vague remembrance, but not 100%.
Okay. At the time of the incident, were you the driver of the unmarked police vehicle, yes or no?
Yes.
At the time of the collision, do you recall what your recorded speed was?
Negative.
Do you recall your speed at all at any point leading up to the collision?
Negative.
Do you think it's reasonable to be traveling at 238 kilometers per hour in a 60 kilometer per hour zone?
I can't comment due to the fact of not remembering the speed.
So it's Your Honor, it's in the evidence. If you want to draw your attention, there you go. It's in the Melbourne Police's evidence, the bottom video, Your Honor. If you want to look at that, I've also got the defense evidence at the very top. It shows the speed of the vehicle, the speedometer.
I will ask the witness to answer the question.
As I stated, I can't remember.
It's not a fact about
yeah, it's not a
remembering, it's a fact of do you believe that the speed of 230 kilometers per hour is reasonable? That was the question posed by the plaintiffs. It does not need your involvement of memory.
Oh, fine. Depending on the call.
Do you remember what call you were going to?
Negative.
During your response, did you activate your siren at any point?
Not that I cannot remember. Cannot recall.
Okay. And yes or no, did you go through at least 3 red light intersections before the collision?
Cannot recall.
So where the incident occurred, there is 2 intersections just before it. Did you go through those intersections, or did you teleport over them and through
Objection,
them?
relevance. Teleportation now?
I will sustain the objection by the defense. I'll ask you to rephrase your question, Mr. Foster.
I'll move on now. Mr. 184, did you slow down at any of these intersections, yes or no?
Cannot recall.
Did you slow down at all during your response time?
Cannot recall.
Just want to for what class driver's license do you currently hold, or did you hold at the? Sorry, I'll rephrase that. What class driver's license did you hold at the time of the incident?
Gold class.
And what does the gold class license allow you to do opposed to a member of the public?
Can you repeat your question, sorry?
What does a gold class license allow you to do opposed to a member of the public?
Is there any chance you could rephrase a little? I just don't understand the final part.
So what does the gold class license allow you to do compared to a regular member of the public? So what can you drive? What conditions does your license have compared to my clients that allow you to do what?
Gold class permits unrestricted speeds, and other things that am I allowed to announce what it does, Your Honor? Because it's going into the policies and procedures.
Yes.
Yeah, how does he know about police procedures now?
Excuse me, Your Honor. Who is this guy?
I'm requesting that
I will not have people insult my beautiful sheriff officer. He is a member of the courts. He is my employee. He's not Melbourne Police's employee. He is my employee.
You can't interject, Your Honor.
Well, considering he's my employee, if they want to start dancing, I'm fine with that because they are my employees. But
he's talking to the witness, Your Honor.
He can talk to the witness. He's a sheriff's officer. If he wants to have
You're in question.
Absolutely.
Can I sidebar with you, Your Honor?
Absolutely.
Would you like me to step down, Your Honor, so I'm not involved in this conversation?
You're fine. Mr. Jackson, please come up.
Yes, Your Honor.
Can you hear me?
Oh, yes.
Hudson.
Your Honor, there is absolutely no way you can allow a third party to communicate.
He's not the
make
third
themselves
party. He's
involved.
a member of the bench, technically speaking.
But he's not a. If he was a tipster, possibly, but he's a sheriff, he can't get himself.
He is my
involved in
tipster.
He's a sheriff.
And sheriffs in the city are also my tipstaff.
Okay, but don't you think it's a little bit unreasonable to have somebody?
Oh, potentially. Oh, absolutely.
Comment.
If you want to appeal this case to the Chief Justice, have this case thrown out and dismissed because of what I've said, be my guest of honor. But I will come to my decision.
Interject.
That's from my knowledge as to Mr. Morris's discretion, though. Not really.
I'm not your mate.
What?
I'm sorry, gentlemen. Let's all be nice here. Let's take out the Hawaiian t-shirts just for a second.
You can refer to me as my name.
No, it's in, mate.
Yeah, you don't need to keep on saying it.
Gentlemen. In relation to the fact of a gold class license, can I just ask the relevance of this question, just on a?
I'm trying just to determine, obviously, if Mr. 184 had breached his license conditions during the operation of his vehicle, because if he had breached his license provisions, that also does back up our matter of negligence on his behalf and breaching his duty of care. You cannot sustain
a brief. I'll have the court enter into a brief period of recess while I consult my superiors on this matter.
Did anyone else see that? Yeah, you UK 184. Did you see that, Sheriff?
All right, I believe I've come to a decision on this question. I'll ask the witness to come back up.
Just give me a couple of seconds, sir. I kind of
No
went
worries.
flying when I jumped off the seat.
That's fine. Given the fact that the details of a gold license is the classified nature of Melbourne Police policy and protocol, and given the fact that we have not come to a conclusive basis that that information shall be provided in this public setting, I will prevent that line of questioning from continuing, but you may move along to other topics.
Used the word he used prior to the brief recess where he stated it allows unrestricted speed. As that was stated to the court.
I will strike that from the record at this time as well.
Okay. So what would you like us to deem a gold class license as your own?
Move away from that topic altogether.
Okay. Mr. 184. Is there a common knowledge, or is there a understanding while you're operating a police vehicle, it requires you to slow down to clear intersections even in urgent duty driving?
Wouldn't this still fall under police procedures, Your Honor? Sorry, I'm just
I didn't
clarifying
ask
before
for
I
it.
answer due to the fact of the way he's asked this question.
I said, is it knowledge, not a police? Is it going to be common knowledge for your safety that you slow down to clear an intersection even when you're in urgent duty
I will
driving?
allow that line of questioning.
Okay. Can you repeat your question, sorry?
Is it common knowledge or knowledge to yourself and others within Melbourne Police that you slow down to clear an intersection even while in urgent duty driving conditions?
It's based on the necessity of what we're doing and what call we're going to.
So the call's urgent, you're just going to fly through an intersection, correct?
Wouldn't say flying, but you still
Well,
have to get priority.
You just said it's based up to the coal. So you didn't say that you would. You said it, like, let's say it's a high priority coal. Would you slow down to go through an intersection to prevent the risk to yourself and others?
You always hang on.
Objection confusing.
I will overrule that objection. I will ask
Can you
the
answer the
defense to
question,
rephrase
please?
the question potentially. Sorry,
The
the
plaintiff, you mean?
plaintiffs.
So, is it knowledge? Are we still on? Which question are we up to, Your Honor? Are we going back to the clearing the intersection?
Yes.
Okay. So, is it your knowledge, or is it knowledge to yourself that even while in urgent duty driving conditions, you slow down to clear an intersection so you're able to assess the area and ensure you don't pose a significant risk to not just yourself, but other members of the public in the area?
Sorry, I'm just trying to think of how to word it. Sorry.
It's a very simple thing to answer.
Your Honor, it was a long question.
It could be a yes or no answer.
Sorry, to the defense, did you bring anything up, sir?
Your Honor, I was just stating that it's quite a long question and the witness should be given time to answer.
That's fine.
So we're trained. It sort of falls into our gold class, Your Honor.
It absolutely
And-
doesn't. It will apply to every single police member.
I will agree with the plaintiff. That is a general,
It's
non-quantitative
still-
question. I'm not. If
Your Honor,
I
can
would,
I
I
Just
would
because you have a gold
severely-
class license.
Mr. Foster,
Once again.
I didn't hear you speaking, Your Honor.
I would advise you not to argue with the bench on my decisions. I will ask you to answer the question posed by the plaintiffs.
Affirm, Your Honor. So our training that we have, gives us reaction time and speeds that we can do with our driving.
So your So do you think it is reasonable to expect that police slow down at intersections to clear it? Yes or no?
Yes, Your Honor. That thing that we spoke about. It's that time.
I'm well aware
But,
there's 8:43. We'll try. I will advise Mr. Foster to wrap this up as quickly
2
as
minutes,
possible.
Your Honor.
Oh, very well.
So, Mr. Carter, I'm sorry, strip that from the record, Your Honor.
Your Honor,
We will
That's-
strike anything in relation to 184's real identity to this matter, and I will
Your Honor,
pretend
he
that.
just gave it to the public here.
Yes. If you want to file a government complaint, you may do so on your own accord, but as far as I'm concerned, we'll continue as such.
Mr. 184, did you, as the driver, slow down at either intersection approaching the collision site?
I do not recall.
So, yes or no, is the swerving allegation made by yourself after the incident during the traffic stop, is that your own personal observation?
What are you trying to ask, though?
I'm trying to ask, the swerving allegation you made during the traffic stop, was that a personal observation of yours?
Yes.
During the traffic stop, did you say to my client, quote, "Are my lights on?" Yes or no?
Cannot recall.
Mr. 184, do you believe lights alone give you the right to break all traffic rules? Yes or no?
Objection. Officers are exempt if they have the lights on from the Traffic Act.
What
they still have to
subsection is
exercise their
that?
duty of care.
Well, that wasn't the question, Mr. Foster. That was.
That will be my last question as well, Your Honor, by the way, just for your knowledge.
I will sustain the objection by Melbourne Police.
Sustain it?
Yes.
On what grounds, Your Honor?
I'm sorry?
Where's the subsection of that you requested? I didn't hear that.
Section 12 of the Traffic Act.
That'd be correct. Please take a seat, Mr. Foster.
Your Honor, if we need to, I can keep this going for 5 more minutes.
5 more minutes will be plenty of time, hopefully, for Mr. Jackson to complete your cross-examination.
I'll try and push it a little bit longer, but we'll see what we can do.
We'll
I can
see.
Stay at the time, just so you're aware.
Mr. Jackson, please come up.
Is he concurring with?
It's Section 12 Traffic Act. Your Honor, I do have quite a few questions, so I don't believe this cross can be completed.
Well,
We'll do it.
Let's try to make it as efficient as possible. Let's make the Melbourne court system efficient for once in an eternity. That'd be fantastic.
I'll try and push the other thing as long as I can.
That's fine.
No problem. 184, were you driving the vehicle at the time of the incident?
Yes.
Lovely. Did you have your emergency lights on?
Yes.
Okay. When you were driving, the lane that you were in the left lane, were there any vehicles in that lane initially?
I cannot recall.
I understand. Did a vehicle merge into that lane? Sorry, I'll rephrase. Did a vehicle swerve into that lane?
Yes.
Was this vehicle?
Objection, Your Honor.
Under what grounds?
The witness earlier, when I asked a very similar question, said he could not recall, and now he recalls it.
At the end of this court case, all witnesses will be reviewed by an external panel by the courts. Any perjury claims will be decided by us afterwards if it's deemed necessary. You may continue, Mr. Jackson.
184. Did you witness Jungle MCL indicate at all?
I cannot recall.
Understand. Did you witness Jungle MCL on his phone while driving?
I cannot recall.
Understood. Just to clarify, were you driving in the left lane?
I cannot recall what lane I was driving in.
Understood. When the vehicle crashed into the police vehicle, what did happen to the vehicle afterward? What happened to it, sorry?
Like,
As in, like, did the vehicle remain stationary?
I can't recall.
That's okay. No further questions, Your Honor.
Very well, to the witness, you may be excused. The court appreciates your time and input into the civil matter. You may return to the gallery or you may leave at your own accords.
I might be able to return, Your Honor, but we'll see.
Alright, my apologies, 184 Bravo. You may return to the stand, and I do deeply apologise for the very sudden delay over your witness testimony, but we'll recontinue as such. To Mr. Foster, you may begin.
So Miss 184 Bravo, at a speed of 238 kilometers per hour, a vehicle would travel the 148 meters as outlined in Exhibit H in approximately 2.1 seconds. Do you think it is reasonable that in 2.1 seconds that a driver may indicate off the curb and into traffic?
I'm sorry, I don't know how to answer this question. I'm not an expert on that kind of thing.
It's obviously from your personal experiences. So in 2.1 seconds, so if you look in your mirrors and your blind spot, etc., when pulling off a curb, do you believe there is a 2.1 second delay between you looking through your mirrors and then indicating an off the curb?
Objection, Your Honor. Speculation, do you believe?
I will sustain.
Sorry, not speculation.
I will allow the line of questioning. You may continue.
During when my client was at the police station, as outlined in Exhibit J, you're heard saying to my client, quote, "You could have lost your license if we were highway, but we are being generous." Do you recall making that statement at all?
I do not recall.
So do you, by any chance, do you recall what you may have meant by that statement?
No, I do not
Your
recall.
Honour.
I'm simply asking the witness what he thinks she may have meant by that statement that she made, which is heard in Exhibit J.
I will allow this live questioning.
I do not recall.
Did you observe Mr. MCL swerve at any time?
Yes, I did.
And in your own words, what do you define as dangerous? Or let me expand that, dangerous driving.
In my own words, there are quite a few
Or the
things
legal
that.
definition if you have one. If you can recall the legal definition.
Sorry, repeat the question.
So in your own words, or if you do have if you do recall the legal definition, in what do you consider or what is considered dangerous driving?
I would consider any actions that may result in harm in another person considered dangerous driving.
At the crash, was there any injuries?
I do not recall.
Were you injured at all? Did you go to a hospital or anything?
I did not visit a hospital, no.
Did you have to visit a GP or a doctor or undergo any medical observations after the incident?
No.
Did you have to take any time off work due to the incident that occurred?
No.
Are you aware of any of the other people that were located inside of the police vehicle that had to take time off work or were injured?
I do not know.
Do you recall any visible injuries to yourself or your partners in the vehicle?
I do not recall.
You don't recall any injuries to yourself or
To the other people in the vehicle.
to yourself, do you?
Not injuries enough to visit a doctor, no.
What injuries did you have then?
I do not recall.
But you just said you had injuries that didn't require you going to a doctor. You just said that.
Objection relevant, Your Honour. This is a charge dangerous driving without injury.
But
Injuries.
Your Honour, the witness has informed the court that her definition of dangerous driving is driving in a manner that causes harm to another person. She has stated previously that she wasn't injured. However, now she states that she was injured that it didn't require medical treatment. She's contradicted her original statement of her definition of dangerous driving. Further, she then contradicted her own statement by saying that she wasn't injured and then changed it in a separate question to saying that she was injured, but she didn't require treatment by a doctor.
Given the fact that you have opened the door to this live questioning, I will allow it. I will overrule the objection. You may continue.
I don't even
Sorry.
remember what the question was. So what injury did you then have if you required medical treatment? Or if you didn't require medical treatment? What injury did you sustain from the incident?
I mean, I don't recall.
You just said you did have an injury.
I did have injuries, but it was I don't recall what they were.
Then why did you lie to the court earlier saying you didn't have injuries? Then you said you did have injuries, and now you then you said you had injuries, but you didn't have to go to a doctor. Now you're saying you don't recall what the injuries
Objection
were.
argumentative, Your Honour.
I will sustain the objection.
And Miss 184, the final question. What are you aware what the burden of proof is in a criminal matter to find somebody guilty?
Sorry, can you repeat the question?
Are you aware what the burden of proof is in a criminal case to find somebody guilty?
Either physical or mental intent.
No, the burden of proof.
Are you able to rephrase the question for me?
What is the burden of proof in a criminal case?
Mr. Foster, what you're asking, you're also wrong in that regard. I will intervene on this matter. You may be looking for the standard of proof, not the burden of proof.
Oh, yeah. So, yeah, I'm not fighting on. There you go. What is the standard of proof in a criminal case? My apologies, Your Honour. I am out of it.
Sorry, can you repeat the question?
What is the standard of proof in a criminal case? So to find somebody guilty of a charge, of a criminal charge, what is the standard of proof related to that? Are you not able to answer the question?
Beyond reasonable doubt that they've committed the crime.
Is there a reason why it took so long?
I
answer that?
am.
Mr. Foster,
Your Honour, I'm just saying. I'll rest there, Your Honour.
thank you. We'll now begin cross-examination. Mr. Jackson or Mr. Sculver, you may now come forth.
Can you please state your call sign or your call sign at the time for the court, please?
184B.
Thank you. 184B, where were you seated in the vehicle at the time of the incident?
I do not recall.
That's okay. Did you have a clear view of the road ahead?
Do not recall.
Understood. Did you see Mr. MCL's vehicle before the collision occurred?
Sorry, can you repeat that question?
Yep. Did you see Mr. MCL's vehicle, Jungle MCL? Did you see his vehicle before the collision occurred?
I do not recall.
Okay. Did you observe MCL using any indicators before the collision?
I do not recall.
Please describe, to the best of your knowledge, what happened that caused the collision. What caused the collision?
I don't recall the fine details, but I do recall seeing like him on the phone after the collision had happened, but nothing. I don't recall anything before that.
Understood. When you say he was on the phone, where was the phone located?
In his hand.
Understood. So, okay. Your Honor, no further questions for this witness.
Very well, the witness, you may be now excused. The court appreciates your time and input into the civil matter. Does the defence have any other witnesses you wish to bring forth this evening?
Yes, Your Honour, we wish to bring forward the plaintiff, Mr. Jungle MCL.
Mr. MCL, please come forth.
Just up on the stand.
I
where she
need
was
to remind you, Mr. MCL, the use of a mobile device will land you in contempt of court and the dismissal of your case.
Oh.
Just give me a moment.
Because my mobile phone muscle is against my thing, so I have to use that muscle to get up. That's why.
All right. Mr. MCL.
Yes.
Miss MCL, do you... Oh, my apologies, I'm a bit tired. Miss MCL, do you swear that the evidence you're about to give us will be the truth, the whole truth, nothing but the truth, so help you God? Mr. Juggler MCL, is the evidence you're
Yep.
about to give us shall be very well good. Mr. Foster, you have the floor.
Mr. MCL, can you tell the court where you were driving to on the night of 10th of July 2025 when you were involved in the collision with Melbourne police?
Yes. I was driving to my mother. She was bleeding out on that night.
Thank you, Mr. MCL. What were the traffic and road conditions like that night, if you can recall?
It was dark. I was behind a local car, and I was trying to make a lane change, and then I heard sirens coming towards me really fast. Couldn't react in time, and then I got hit straight into a pole, and then um, stopped and hitting the side wall.
Mr. MCL, did you suffer any injuries at all from the collision? Did you suffer any
Yeah,
physical injuries or a concussion, anything similar like that?
yeah. I got a little bit concussed, and I was confused. Didn't know what was going on.
Okay, thank you. Have you driven on that stretch of road before?
Yes, I have.
Okay, thank you. And do you recall at all what speed you were traveling just before you attempted the lane change?
I believe at 40 miles per hour.
40. And did you check your mirrors before you made the lane change?
Yes, I did.
Can you explain what you saw in your mirrors when you checked them before the lane change? Did you see any cars approaching from behind you?
I saw no cars, but then when I looked in front, I heard sirens coming towards me, and there was a police car.
Did you hear sirens or did you just see them?
I hear sirens. I didn't say sirens.
Okay. So you did hear a police car coming up from behind you with its sirens on.
Yeah, just before it hit me.
Are you sure, Mr. MCL?
Yep.
Do you think you may have heard the sirens due to a concussion?
Maybe.
And when did you and where did you seek the medical treatment?
Could you please repeat that question?
Where and when did you seek the medical treatment? Was it after you had been released from community service, and where did you go to receive it?
It was after I had community service, and I went to hospital at 149.
149. Thank you. Did you have any reason to expect a vehicle to be approaching at such a high speed from behind you when you made the lane change?
Nope, not at all. It was totally unexpected.
And what was your first indication that another vehicle had collided with you?
When I slide and hit the wall,
How quickly did the collision occur after you first became aware of the other vehicle?
it was really quick. It was in a blink of an eye.
Can you explain or describe what damage occurred to your vehicle during the impact? Was there smoke coming from your vehicle, and what parts of your vehicle were damaged?
There was no smoke coming out of my vehicle, but my back bumper of my vehicle was damaged, and also the front bumper and the side of my door was really dented.
Was that the driver's side or the passenger side that was dented?
Um, I do not recall. I think it was the passenger side.
And how did you think the police behaved immediately after the collision? Did you? Sorry, I'll already say that. How did you? How did the police behave immediately after the collision?
Could you please say that again?
So, how were the police during the traffic stop? Were they disrespectful or were they very polite and nice?
They were really disrespectful to me after they just hit me with a car. I was traveling at a really fast speed.
And Mr. MCL, yes or no? Did you feel like you were the victim of the crash and you were being blamed?
Yes,
And how were the police being disrespectful to you?
they said I was reckless driving when I was making a lane change, and they also pulled me, asked me to step out of my vehicle and detained me.
And were you informed of the reason of your arrest when you were asked to get out of the vehicle?
Um, I do not recall.
And was any property, yes or no? This is a yes or no question, Mr. MCL. Was any property seized from you that night?
Yes, my
Yes or no? Yes or no?
800K.
Yes or no?
Yes.
And can you tell the court what property was seized from you?
Um, it was my 800K cash that was in my wallet.
And Mr. MCL, is it true there was another approximately $300,000 in cash also on you that was not seized by Melbourne Police?
Yes, there was I think 270K cash in the other pockets of my wallet.
And was that seized by Melbourne Police?
No.
Did they explain why that wasn't seized?
No.
Okay. And were you charged with any offense in relation to that money that was seized? So did, aside from the driving without causing injury, did Melbourne Police charge you with anything related to that money?
No.
And a yes or no question, did the incident have any impact on your income?
Yes.
And Mr. MCL, what job do you do?
I'm a taxi driver. I'm drive limo around the city to pick up customers.
So do you use your own, vehicle that was involved, do you use your own personal vehicle to commute to and from your workplace?
Not that vehicle. I use my limo.
But to get from your house to work, do you use that vehicle that was involved?
Yes, I do.
Okay. And how do you earn your income? Is it done by a cash or card? Like, do they pay you when they get into or after the trip, or is it all prepaid through your business before the trip?
Could you please repeat the question?
So when you for work, you said you drive limos, correct?
Yes.
So is your payment received in cash after the trip from people?
Yeah, my dad paid me.
Your dad paid you. Okay.
Yep.
And was this $800,000 worth of money? Was that earned over a long period of time through work?
Yes, that was earned over a long period of time.
And was it all earned through work, or was it earned through other methods or gains, such as your parents or loans?
200K of that was loaned from my mate, and um, the other 600 was from my dad paying me.
Okay. And Mr. MCL, is it true that on the night, 94 tablets of LSD, which is an illicit substance, was that seized off your person?
No,
It wasn't.
I did not have any of those LSD on me at that time.
You didn't have any LSD.
Yeah.
Your Honor, can I withdraw that question from the record, please? That was relating to another matter that I just got mixed up.
Unfortunately, no.
Mr. MCL, there were there's some electronic devices on you. Were you charged by Melbourne Police for possessing those electronic devices, or were they just seized? Yes or no?
Only the money was seized for me.
Okay. And Mr. MCL, on the night of the 10th of July, why do you believe you were not driving dangerously?
Because I was driving in a sensible manner. I was just trying to make a lane change.
And Mr. MCL, would you consider yourself as safe driving?
Yes.
And the final question, Mr. MCL. If you could summarize the main cause of the collision, what would you say it was?
Could you say that again?
So if you could say, well, what do you think was the main cause of the collision? Was it your fault? Or was it the police's fault?
It was 100% the police fault.
Okay. Thank you, Mr. MCL. The plaintiff will rest, Your Honor. I just say there, Mr. MCL, the defense will question you now.
Very well, to the defense, can you please come forward? You may begin your cross-examination of the witness.
Understood. Give me 5 seconds, Your Honor, sorry. Okay. Mr. Jungle MCL, were you driving the vehicle in question on July 10th, 2025?
Yes.
Mr. MCL, were you on your phone while driving?
Yes.
Mr. MCL, when you changed your lane, did you indicate?
No.
Why?
Because I was trying to make a lane change.
Mr. Jungle MCL, do you have a driver's license?
Yes, I do.
Are you aware that you are supposed to indicate when you change your lane?
I think my indicator might have been blown at that time.
Right. You were driving without functional indicators.
No, I wasn't.
Okay.
I'm saying the car didn't have indicators.
Mr. MCL, how does a car not have indicators?
I think that's a question you should ask the city.
Your Honor?
Some cars do have indicators, and I believe that specific model of car, I think I do own it. I believe if you do flex your left or right arrows, it will indicate. You may continue, Mr. Jackson.
So you were driving a vehicle with unoperational indicators and tail lights as shown in the body cam footage. Now, Mr. MCL, the footage that you yourself have supplied shows you looking over your shoulder multiple times before the before the collision occurs. It is within the first 2 seconds of the footage you've supplied that you can see the police vehicle traveling with its emergency lights on. You can see the lights illuminating the surrounding area. And earlier today, you stated that you checked your mirrors and saw 0 vehicles. Why is this?
Um,
Speculation, Your Honor.
Overruled. Mr. MCL, I must remind you that you must answer this question, otherwise you'll be charged with contempt of court.
yep. Could you please repeat that question?
Of course. So, the footage you have supplied to this court shows you looking over your shoulder multiple times, and the police vehicle is clearly shown with its emergency lights on, which, sorry, the lights, the word for it. You can see the emergency lights, you can see the vehicle. They are lighting up the surrounding area. Earlier today, you stated that you checked your mirrors and you saw no vehicles. If it is not true.
I think because there was a blind spot in the road,
Where was the blind spot?
because I was behind the local car and the light was coming, but they were coming too fast.
Right, so you're saying they were traveling so fast that you
Yep.
couldn't see the lights of the vehicle. Is that what you're saying?
Yeah.
Give me one moment, Your Honor.
Excuse me.
Your Honor, I would like to note that in the evidence submitted by the plaintiff, titled Exhibit A, Vehicle Collision and Stop, you can see within the first 2 seconds of that footage, and even the first frame of the footage, you can see the police vehicle with its lights surrounding.
Objection, Your Honor, prejudice. In that footage, if you go to the second frame, literally the second frame after that, you can see the lights turn off in that frame. There are 2 poles, 2 separate poles, blocking the police vehicle from my client's view in conjunction with another vehicle. I don't think it is possible to determine that my client looked at every single detail in his rear view mirror or his side mirrors at the time of the collision.
That's a great argument, but it is by all means not an objection to the line of questioning being proposed by the defence, and in that regard, I'll overrule the objection. You may continue, Mr. Jackson.
Understood. Okay. Mr. MCL, earlier on, you stated that you heard sirens. Is that correct?
Yes.
Mr. MCL, why did you lie to the court today?
Objection, Your Honor.
Under what
Client
ground?
clearly stated that he had a concussion. A concussion can be associated to a memory and cognitive functions after the collision.
I do not have any medical records submitted to this court on this subject, so for now you may continue with your questioning, Mr. Jackson.
Mr. MCL, why did you lie here today?
Um, because I did not lie.
So, let me just rephrase. Earlier on, when Mr. Foster was questioning you in regard to this incident, you said that you heard sirens. In the body cam footage submitted by both the plaintiff, yourself, and the defense, sirens were never activated until after the collision.
Yeah. The incident was a month ago, so kind of not remember some part of it.
Okay, so you've stated. Are you saying that? Okay, give me 1 second. You've already stated twice that you heard sirens. And now, when I'm showing you what actually happened, you change your story and say you can't remember. Why? Okay. Mr. MCL, when you were arrested, actually, sorry, I'll back a little bit. Mr. MCL, were you pulled over as a result of this collision?
Pardon?
Sorry. Were you pulled over by police following the collision?
Yes.
When you were pulled over, what happened? Walk me through it.
When I was pulled over, told the police to, I do not, but I said something about their driving, and they decided to turn their lights on and pulled me over.
Okay. Were you ever arrested on this traffic stop?
Yes.
What reason did they give you as to why you were arrested?
Reckless driving.
Okay. And in the body cam footage submitted by yourself, I'll quote it for the court. Give me 1 second. Exhibit H, vehicle interception, submitted by the plaintiff in this matter. Within that footage, the officer asks, what is the reason for the driving? Sorry, the reckless driving. Do you recall that?
Yes.
Do you recall what your response was?
No.
Okay. 1 moment. Okay. When you were arrested, were you transported to a police station after that?
Yes.
Okay. And while you were in custody, what was seized off of your person?
800K cash.
$1,000 cash. Okay.
Yep.
Is there any reason why you were carrying this amount of cash on your person?
Because I like to carry cash on me. Is that an issue?
Just a question. Now, that $807,041, was that earned legally?
Yes.
Okay. Mr. MCL, you've already misstated yourself once. I'd like to warn you for this next question that you are under threat of perjury. That $807,041, sorry, it's $41, was that clean money?
Not sure.
Objection, Your Honor.
I'm pretty
Under
sure
what
it was.
grounds?
Objection, Your Honor.
Under what grounds?
The money of question was seized by Melbourne Police and it was deemed by them to be unlawful. As the arresting member quoted, "I've been around a long time." So
That's an
Melbourne Police
argument, but
already
is by
deemed
all
the money.
means
That's a leading
not an
question, Your
objection.
Honour. Melbourne Police already deemed it as illegal money somehow.
Right.
An officer may have deemed it legal by those quotation of words, but in this court it is up to the prosecution and yourself and counsel to make questions to witnesses surrounding such aspects. And I don't believe that your question is that objection is leading in any way, shape, or form. So, Mr. Jackson, you may continue.
Understood. I'll just re-ask the question, sorry. Just a yes or no, that $807,041, was that clean money? Did you earn that money legally?
Yes.
Okay. Mr. MCL, in the body cam footage provided by yourself within the cells, you state on the phone that the money is unclean and dirty. And I will quote the exact timestamp for this, Your Honor. Exhibit 1, Custody 1, submitted by the plaintiff at 1:37 minutes. MCL explains on a phone call to a person called Ben, they're trying to take my unclean money. And then at 2:06, Ben asks MCL, quote, "Wait, am I on speaker?" Unquote, where Jungle replies, quote, "Nah," unquote. Ben then asks Jungle, quote, "Was it dirty money?" Unquote. Jungle then replies, quote, "Yes." Why have you lied again, Jungle?
The money I meant was dirty. As in, it got soaked.
Earlier, okay. MCL, earlier you stated the money was clean. It was earned legally. I've asked you if it was dirty. Sorry. I've asked you if it was clean money, and you said yes. And now, because I call you out on another thing that you've lied on, you change your story once again. Your Honor, I would like to get this witness removed as he is non-credible and unreliable.
Objection, Your Honour.
Under what grounds?
Is that for me, Your Honour?
Yes.
Are we able to get the by the defense? I believe the word term used by him, the word dirty. I think it's ambiguous. Are we able to get that defined from his perspective and what he deems it dirty money as, for absolute clarity in the court?
Your Honor, he's
So my
changed his
client
story
is able to
multiple times.
understand
Yes, the only issue is that would be, in practice, a very good idea if you were the one asking him questions. However, given the fact that he has changed his position on now 3 separate matters, how can I deem this witness to be reliable and, in my opinion, very much eligible for the charge of perjury? How do you expect me to trust this witness, Mr. Foster?
Your Honor, Mr. MCL, obviously, I believe obviously we don't have any evidence containing to the concussion. Now, my client and the witness, Mr. MCL, is obviously trying to recall events from 1 month ago. He is a general member of the public who has been through an incident. He's trying to recall the incident the best he can because all he wants today is justice. All he wants is justice, Your Honor. And Mr. MCL is trying his absolute best to recall questions, and he might not get it right. He's not a police officer. He's not been trained, or he's not obviously as professional as these people. He's just a general member of the public trying his best, trying to get his money back that he earned through means. And he might make mistakes. We all make mistakes, Your Honor. He might not absolutely answer a question the right way because he
Your
might
Honor.
not fully understand it, or he may not fully recall the incident, and he simply, Mr. MCL might be afraid to say, I do not recall to some questions because he wants justice so bad. He's absolutely trying his best to recall it. He may have misunderstood the question. We need the term dirty money
Misunderstanding the
clarified.
question?
Your Honor.
He's not a professional individual, Your Honor. He does not hold a professional position like Melbourne Police. He's not able to answer the questions in the same way Melbourne Police members are able to answer the questions. He's just simply a member of the public trying his best at the moment, Your Honor.
My...
Your Honor. He
Yes,
changed his
Mr.
standpoint.
Situations like this.
He has changed his viewpoint on multiple issues, multiple times. And then, every time after I call him out on lying, he changes his story. Why is that? He should
Your Honor,
not be
this is
allowed as a witness.
daunting environment for my client. He is not used to high pressure and high stakes environments. He's trying his best. Honor, to be quite frank, he's absolutely horrified to be here right now. He's obviously in front of a courtroom, in front of tens of people, and he's trying his best to make this work, Your Honor. You can't.
The only issue, Mr. Foster, is that he has had absolute mental... there's been absolutely zero impurities in all these other questions that he's being submitted, which is aligned with evidence submitted by yourself and by Melbourne Police. But on this specific subject matter, it seems that he is... what's the term I'm looking for? Trying to paint something over something that's very well cracked. I will hold my decision to the end of trial. In addition to any perjury charges that may be pending, I will make my decision on that as well at the end of this court case. But for now, this matter, we will continue on. Mr. Jackson.
Mr. MCL, in your possession at the time, you had a variety of different items, and I'll clarify, including lockpicks, an angle grinder, and electronic lockpick. Sorry, I'll rephrase. Lockpicks, an angle grinder, and a bunch of multiple electronic devices. Now, Mr. MCL, what do you do with those lockpicks?
On the
Objection,
side,
Your Honor, relevance. What do lockpicks have relevance to the case at the moment?
Relevance to the money that we have deemed suspicious to the circumstances.
Money and lockpicks have to do.
Are you referring to cable ties?
I'll have members of the gallery remain silent. Any word from anyone in the gallery will be immediately removed from this courthouse, and at my pleasure I may remove all witnesses from this courthouse, and that is final. I will overrule the objection given the fact that these items, I believe, will be relevant as the form of the individual's primary source of income, as I have sustained objections, overruled objections previously when Mr. Foster was indeed questioning the witness surrounding his money and where that money has come from. I do believe that these are relevant questions to the procurement of such funds. You may continue, Mr. Jackson.
Understood. Now, Mr. MCL, what do you do with those lockpicks?
So sometimes I carry lockpicks on me because sometimes the key at my house get stuck sometimes. So I have to wiggle myself in.
Okay. So you're saying that because of
I
your
apologise,
house
just give me a
key,
moment. My ears have decided to
getting
die.
stuck.
Give me uno momento.
I was the ex-locksmith.
Just hold up, mate, until the judge is back.
My most sincere apologies. Can you all hear me?
Yes,
Yes,
Your
Your
Honour.
Honour.
Very well. We'll continue.
Sorry. MCL, you stated that you carry your lockpicks on you because sometimes your key gets stuck. Is that correct?
Your voice was kind of poppy. Could you say that again?
Oh, sorry. Earlier on, that you carry lockpicks on you, just in case your key gets stuck in your house.
Yeah, because I have I'm a ex-locksmith, so I know how to work my ways around locks.
Oh, I see. You're an ex-locksmith. What's a deadbolt?
You're not relevant. He's taking this way off topic.
Your Honor, he's a locksmith. He should know what this is.
Given the fact that the individual has opened this live questioning, I'll have no choice but to overrule the objection. You may continue.
Given an ex-locksmith position, what's a deadbolt?
Could you please repeat that?
What's a deadbolt?
It's a dead metal bolt that slides into a metal strike plate on a door jamb.
Hmm. Okay. Okay. So, sorry, earlier on, bringing back to the lockpicks, how often would you say that your key gets stuck in your house?
2 times a week.
2 times a week. Is that why you were carrying 21 lockpicks on you at the time?
Yeah. Normally I would just need one to get into the house, but had
Hmm.
a bunch from my old jobs, so I just
Okay.
carried 21 on me just in case the other one breaks.
Okay. I see. Do you have any other occupations we should be made aware of? You stated that you were a locksmith, and do you have any other occupations we should be made aware of before we continue?
And also a game developer.
A game developer. What sort of games do you develop?
Um, it depends. I developed some games in my apartment, uh, revolving around arcades.
Right. What do you use your angle grinder for then, mate?
Um, Locksmithing.
You use your angle grinder for locksmithing.
Yeah, because sometimes the the door the lock doesn't. Some locks I need electric lockpicks because they're advanced, and if I can't do that, I have to pull out the last option, which is the angle grinder.
Right. Okay. Give me 1 second. Sorry, I'll finish up very, very shortly, Your Honor. Sorry. Okay. Okay. That is all my questions for this witness, Your Honor.
Very well. After 1 hour and 45 minutes, we've finally gotten through witnesses. I'm very pleased with this. We'll now have another 6 sections to go through in relation to this case. To the witness, you may be excused and you may return back to your desk. Can I make a public outcry for a lovely officer to go buy 5 Uwu kitty bundles if possible? I will pay you an extra tip on top if you can quickly go organise it. Mr. Zaris, I know you are a very leading person. Would you be so inclined as to potentially do a quick Uwu run for the courthouse?
Of course, Your Honour.
Absolutely. Thank you very much, Michael Zaris. Very well. We'll begin on to the next section. The plaintiff please come forth and deliver your application to the court as to why the criminal charges and or evidence pertaining to the case should be overturned / inadmissible / not valid. Please come forth.
It's been a long night, Your Honor. Thank you, Your Honor. To find a person guilty of any criminal charge, sorry, I'll restart that. To find a person guilty of dangerous driving without causing injury, the defense must establish and prove that my client's driving created such a significant risk of physical harm that it represented such a clear disregard for safety expected of a reasonable and competent driver. Like witness 2 stated, dangerous driving is defined as a way of causing harm to another person. In this instance, my client was charged with the charge of dangerous driving without causing injury. So where is the harm and injury? I don't know, Your Honor. The evidence contradicts itself entirely. Within Exhibit A, my client moves from a slow speed before attempting a lane change. The police vehicle is clearly traveling at well above the speed limit. And I now ask the court to look at Exhibit B, Your Honor. The first 10 seconds.
Yes, I've brought that up at this time.
Oh my.
May continue.
Within that Exhibit B clip, you can see that if the 3 police members had been traveling at the speed limit, which is 60 kilometers per hour, it would have taken just 8.8 seconds for them to travel the confirmed 146 meters, which is the first opportunity my client could have seen the police vehicle. 8.8 seconds is ample time and would have given my client time to see the approaching police vehicle. The first visible sighting location is visible in Exhibit D.
Mm-hmm.
In Exhibit D, as you can see, there is still a very large hole from the overpass still obstructing that view. You can only just see the outline of the vehicle in the far distance in the exact position where the collision occurred. From that position, police would have traveled from the Exhibit D location to where that car in the distance is in 2.2 seconds. The police vehicle was traveling at 140 kilometers per hour, you know, it would have taken 4 seconds between the first opportunity site and the collision. If you then look at the members' speed, if they'd been traveling at 200 kilometers per hour, it would have taken 2.7 seconds to travel that distance. And at the speed the police members were driving, it took 2 seconds for them to travel that distance. For a driver to reasonably look in the mirrors and surroundings and begin moving takes over 2 seconds. So for my client to look in his mirrors and turn around, there is well within 2 seconds there. There's no way for a reasonable driver to expect a police vehicle to be traveling at that speed. So how is there an exception for my client? How is there the exception for my client to get done this time? My client could not have reasonably anticipated a police vehicle without a siren to be approaching at the speed of 238 kilometers per hour. That is 4 times the speed limit in that area, Your Honor. And taking into mind the hill and the crest and the blind spot, a well greater duty of care had to have been established. My client had 2 seconds to respond. 2 single seconds. However, still at 146 meters, as said prior, you can just see a very small portion of that vehicle. If we look at exhibit F and G, G being the driver's height and F being a higher view.
Objection.
Under what grounds?
No body cam on F or G. Where's
There's
the photo come
photos. F and G.
from? Where's the body cam?
What body cam?
Well, where'd the photo come from?
Me?
Your Honor, there's
I
no body
used-
cam on his person.
I took a photo
Your Honor.
with my phone. You can't take a photo with a body cam, can you, Your Honor? That takes a video.
So
I took a
where's
photo
the,
with the phone.
so where's so do you have the pictures on your phone right now in City?
They were taken. I can't say that. How do I word it? They were taken in a separate. They were taken and moved onto the emails, Your Honor. It's not reasonable for. When is there an expectation from the court that I must use a body cam to take a photograph, or I must have them on my phone? I believe the court has had other images submitted prior that have been accepted in other cases where a phone or body cam were not used to obtain that. Why is there an exception this time?
Generally speaking, when there are associated images, it is a pinpoint result of greater body cam. It's more to get to the point. I can't necessarily recall a case where I've just seen separate images without proof. Some exceptions we do sometimes make is by officers because there is a legal expectation and understanding that they had previous body cam on, and so those images are automatically deemed valid.
I've had images accepted previously that were accepted. I'll be able to get you the case if you're interested. You're on. I'll just need a few seconds to be able to get that case. They were accepted by the court and used at trial. This is the first time I've ever had an issue with this.
Given the fact that it is from the dash cam of a vehicle, I will deem these to be admissible in this case. If they were off a person, that would be a different case altogether.
You're deeming these admissible? I just want to clarify.
The ones with the points of perspective from the vehicle are admissible in every way, shape, and form. In relation to the two which you have taken of your person, is
Would we be able to be using the refacing dash cam on that vehicle, Your Honor?
yes, that is a reasonable
on that
expectation. However, not from your person, but usually in some cases, I have accepted it from officers and defense that does pass muster.
Would we be able to use Exhibit G, Your Honor, because that is at the same height for the refacing dash cam in that red vehicle, and that's the exact view I would see. Just it would be moved a few.
Do you own
meters
that
forward.
vehicle, sir?
That was a vehicle I met somebody at a garage, asked for his assistance, and I paid him $40,000 to assist me with the photographs.
Well, that's the first time I've ever heard that.
Yeah, I paid him $40,000 to assist me with it because I didn't have a second car to
I'm
use.
guessing it was cash as well.
Yeah.
I don't see any issues with it, so it will.
I think you might actually be able to see him in one of the photographs.
That's fine. I will deem the evidence to be admissible. You may continue.
Thank you. So Exhibit F and G, G being the driver's height and F being a higher view, which would have been similar to my client's. Within Exhibit F, you can see just a speck of that vehicle. Taking into note that this collision occurred at nighttime where visibility is reduced. Between the first visibility site and the collision site, there are two intersections which both use traffic lights. Police are expected and ultimately required to slow down to clear intersections for safety. With the speed the members were traveling at from the collision, there is absolutely no way they could have slowed down enough to clear the first section. And clearly in the body cam footage presented by the defense, they are still going at their highest speed, 238 kilometers per hour through a red light through that second intersection. They were These members were blind to their stupidity and presented an astronomical risk, not just to themselves, but every single person who drove on the Melbourne roads that night. During the traffic stop as seen within Exhibit H, an arresting officer is heard saying, quote, "Are my lights on?" implying that flashing lights alone give him an exception to drive in such a dangerous manner, which posed such a serious and significant risk to everybody in Melbourne. That comment could not be further from the truth. I'd like to also comment on the Traffic Act 2025, Section 12, Your Honor. Your Honor?
Please take it away.
Yep. So, Section 12 of the Traffic Act 2025 states individuals employed by emergency services are exempt from this legislation as long as their vehicle has red and blue lights displayed. Key words here: so long it is safe to do so. That, for me, implies that the wording of emergency services are exempt means they are only exempt as long as it is safe to do so.
Objection, Your Honour. That's mischaracterization. The Act states officers employed by Melbourne Police in a tactical capacity are exempt from the legislation when in high hostility. So it was not high hostilities then, Your Honour.
Just give
The
me one
objection,
second.
Your Honour. When were they in a tactical capacity at all?
No, they weren't. Like, it's not. It's saying.
Wait, what were you trying to argue, sorry?
So it's saying officers employed by Melbourne Police in a tactical capacity are exempt from the legislation when in high hostilities, so long as it is safe to do so. The safe to do so part is relating to the high hostilities, not the entire.
No, I'm referring to the sentence before that.
Understood. When it is safe to do so.
Yeah, and I'm implying that the phrase "as long as it is safe to do so," as if in the words that Melbourne Police still have a duty of care over all road users while driving, and that the exemption doesn't apply if they are driving in a manner that breaches their duty of care. I believe it literally says, so long as their vehicle has red and blue lights displayed, so long it is safe to do so. I don't, my understanding of that specific wording is that they are only exempt from the legislation as long as they are acting in a safe manner, which clearly 238 kilometers per hour in a 60 kilometer per hour zone with just red and blue lights cannot be a valid exemption from the Traffic Act. And if I'm totally wrong, Your Honour, I think that act will need a rewording there.
Oh, after this case, usually something gets changed.
That is the understanding of me reading that aloud, and I think many members of the court will also agree with that wording, that it is only exempt as long as it is safe for them to do that.
Continue.
Marked police cars should exercise an extreme duty of care when driving with lights and sirens to an incident. However, a marked police car with just lights, they should be driving like the safest driver in the world. But these officers involved in the collision were in an unmarked police car with much less visible lighting and not a light bar on the top, reducing the overall light visibility within their vehicle. And they just had their lights on, Your Honour. That is a disaster waiting to happen. And frankly, that disaster did happen. But instead of taking accountability for their stupidity, they grabbed my client and framed him for causing the accident when it was their own incompetence, blatant operational failure, and negligent actions which caused it all. The arresting member later said while my client was in the cells within Exhibit J, stating, "You could have lost your license if we were highway, but we are being generous." This comment contradicts everything he said. He states with saying, "My client could have lost his license," but then he admits he can't even take the license away because he's not even a part of the highway patrol. And then just to put the icing on the cake to cover it all up, he says, "We are being generous to make the police look like they are the fairy in the forest," which they are not. The defense's case is littered with opinions and accusations. A police member during processing, as shown in Exhibit J, shows the arresting officer responding to a question about unmarked bills or the, quote, dirty money, stating, "I've been around a long time and have dealt with a lot of things. Experience can't and should never equate evidence, Your Honor." One of the arresting officers asked, "Wouldn't you rather get there safely in one piece? And your driving was very endangering." These exact quotes should never be and never been directed at my client and should have been placed on a mirror for the police members to understand themselves. Your Honor, summing this all up, my client could only have seen the police vehicle if he had started moving as he had looked behind it. However, he may have looked behind him before moving, hence the inability to see the police vehicle traveling anywhere. Seeing the police vehicle that was traveling at 4 times the speed limit. 4 times. My client had 2 seconds, a 2-second time period to see the police vehicle coming over a significant crest and dangerous blind spot. The police neglected to slow down for. This collision did not cause injury. The definition of dangerous driving given by the witness was it causes harm to somebody. Nobody had injury, Your Honor, and that is in the wording of the charge. Where is the evidence of swerving prior to the collision? There is a lane change. A lane change is not swerving. There is no dash cam footage to prove this, and only subjective commentary from police members making ridiculous and integrity breaching comments through the incident. Therefore, the plaintiff believes there is significant doubt as to whether there was an act of dangerous driving at all backed up by the defense's own witness and one of the arresting officers. Thank you, Your Honor.
Very well. We'll now have the defense please come forward and make their application to the court as to why the criminal charges and or evidence pertaining to the case should remain valid, not overturned, and admissible to this case. You may begin.
Your Honour, as labelled under Section 5.2 of the Traffic Act 2025, dangerous driving without injury states that, quote, "an operator must drive in a manner that is safe for other operators and pedestrians. If found to be operating a motor vehicle dangerously, quote, such as ramming, pushing, ignoring road closure signs, or swerving, however, did not cause injury and or fatality," the Act then lists the applicable penalties. Meaning, Melbourne Police are not required to defend that this has caused distress, injury, or fatality, only that Jungle MCL's conduct whilst driving has posed an objective danger to the public. I'd like to point your attention to the footage submitted by the defence, the footage being 6 minutes and 58 seconds in duration. The defence would like to walk the court through the first 10 seconds of that footage when ready.
Just give me a second.
No problem.
All right, you may begin.
Okay. At the time of the beginning of the first body cam footage, sorry, it was dark. The police vehicle was traveling at over 200 k's an hour with its emergency lights activated. The lights were clearly illuminating the surrounding area as the police vehicle moved. As stated, officers are exempt from the Traffic Act 2025 as long as they have their emergency lights activated as per Melbourne legislation. Yes, when safe to do so. However, the circumstances relating to the officers and where they were going, what call they were attending, is unknown. Regardless, Mr. MCL has decided to pull in front of a black vehicle in the right lane and then also swerve into the left lane that a police vehicle was lawfully using. MCL did not use his indicators to show his intention to merge. MCL did not attempt to make other drivers aware of his intention to merge. Sorry.
Walk
Just
around.
back to the comment of the swerving quote.
Is this an
swerve-
objection or is this an argument?
No, it's an objection to a comment he made.
All right.
Mr. Jackson made a comment saying, quote, he swerved in front of a black vehicle in the right lane before swerving back into the left lane. There's no evidence to suggest that my client was in the left lane prior to the collision before the lane change at all.
Well, thank you for the argument, but it's not an objection, so I'm going to overrule it in all capacity. You may continue, Mr. Jackson.
Thank you, Your Honor. MCL did not attempt to make other drivers aware of its intention to merge, and MCL did not even wait for the two vehicles to pass by him before merging. Instead, MCL was pulled out in front of two vehicles, causing a collision with a police vehicle, which then led to a traffic stop. Still, within this crucial 10 seconds of the body cam footage provided by the defense, at exactly 4 seconds, you can see MCL was on his phone while driving, which, when considering the failure to indicate, the failure to give way to an emergency vehicle, the failure to show regard for other road users and drivers, it becomes clear that at the very least, this was reckless. MCL was reckless, and this recklessness has caused a high-speed collision, which was dangerous. Regardless of intent or reason, MCL has caused a vehicle collision with an emergency vehicle, which was clearly visible. Even if fast-moving, it was a dangerous act, and thus it falls under dangerous driving without injury. Your Honor, MCL, through his own actions, has caused an objective danger to other road users through his driving. Danger is not the presence or happening of harm, but the potentiality of harm. And in this instance, there was a large potential for harm. It goes without saying that vehicle collisions more often than not result in injuries, and vehicle collisions more often than not are dangerous. The conduct of Jungle MCL's driving in this instance was dangerous. Senpai, I'd like to attention to Exhibit A, vehicle collision and stop, submitted by the plaintiff. When you're ready, Your Honor.
You may continue.
Between 0 and 2 seconds, you can see MCL is in his vehicle, one hand on the steering wheel, while the other was on his phone, which was to his ear. MCL was driving. It appeared in a diagonal direction across the lane. He's looking over his shoulder, and multiple frames of the footage clearly show an emergency vehicle with its emergency lights activated traveling toward MCL. MCL then turns away momentarily from the police vehicle, continuing driving, before looking again, seeing the police vehicle while swerving into the left lane, causing a collision with the police vehicle. From this footage, we can affirm that the police vehicle was visible prior to the collision. We can affirm that the lights on the police vehicle were also visible prior to the collision. We can affirm that MCL was mid-conversation on his phone when he caused a collision. We can affirm that MCL did not signal his intention to merge, and we can affirm that there were 0 obstructions from his viewpoint that could have limited his view of the police vehicle or its lights. That is all currently, Your Honor. That's all.
Very well. You may take a seat. Move on to the next component of this case. Can the plaintiffs please come forward and deliver your application to the court as to why civil remedies are warranted given the circumstances of this case?
Thank you, Your Honour. The plaintiff seeks compensation for Mr. Jungle MCL, whose rights were fundamentally breached during and after the unlawful and negligent actions of Melbourne Police on the 10th of July 2025. The criminal allegations against my client are unsupported by evidence and rest entirely on flawed police conduct. Conduct that not only caused unwarranted criminal proceedings, but inflicted direct and substantial financial loss, mental anguish, and reputational damage to my client. The civil remedies we seek are proportionate to the measurable harm caused. Our remedies we seek are all supported as the defendant owed Mr. MCL a duty of care and failed to uphold that duty of care, breaching it. Further causation can also be proved as the direct link to this trial is due to the actions of Melbourne Police and the collision. That is every single element of negligence ticked off, Your Honour. Every single element. The plaintiff seeks the following compensation. We seek the return of the seized property, the $807,041. This sum was seized without the lawful basis, labelled unmarked bills, without verification or evidentiary testing, and no related charge was filed. This constitutes unlawful deprivation of property, entitling my client to immediate return of the full amount, plus damages for loss of use. The compensation for legal fees, due to the length of this evening's trial, has actually been updated due to the length I've been required this evening. The compensation for legal fees is $580,000.
We'll get to this at the very end. Legal fees for now are more than fine. You may continue.
Okay. The protracted and unnecessary proceedings have forced my client to incur a substantial amount of legal fees. These include extensive preparation, multiple consultations with my client, document drafting, meetings, and representation across both the trial this evening and attempted mediation with the defence. The costs directly attributed to the police's wrongful actions. The plaintiff also seeks $100,000 for compensation that reflects both the physical repair amount to my client's vehicle and the time in custody spent, including the significant hardship he endured. Would you like me to state the total civil remedy amount, Your Honour?
Continue. We'll figure this out at the very end if required.
That is all from me, Your Honour.
Very well, you may take a seat. Can the defence please come forward and make your arguments to why civil remedies are not warranted in this case?
Yes, Your Honour. Would I be able to point your attention to Exhibit 1, Custody 1, Your Honour?
Yes.
Okay. I'd like to point out that at, step by, 53 seconds in that footage, this is relevant, MCL calls a contact on his phone called Ben La Familia. This was whilst in police custody in the cells. At 1:04, MCL states that he, quote, got done for reckless driving, they're searching me, unquote. 1:37, MCL explains to Ben, quote, they're trying to take my unclean money, unquote. 2:06, Ben asks Jungle, quote, wait, am I on speaker, unquote, where Jungle replies, quote, nah, unquote. Ben then asks Jungle, was it dirty money? Jungle replies, yeah. 2:25, Ben states, you can just say, did they ask why it's separate or something? They can't know it's dirty money, you know that, right? From this body cam footage, we can affirm that MCL, after being uncuffed, acts within his rights and makes a phone call. MCL calls a person called Ben, and MCL, after hearing that Ben is physically unavailable to assist, continues to explain the situation to him. MCL makes no attempt to ring a lawyer, and he makes no attempt to hang the phone up. MCL states multiple times that the money seized was unclean and dirty. Ben begins to then aid and abet MCL, creating a fraudulent and unverifiable story. I'd like to point your attention to Exhibit J, Custody 2.
Mm-hmm.
At 34 seconds, Ben starts to speak, and MCL begins to copy everything Ben is saying. Ben says, "Say you did it. You drove someone for a taxi. You drive a taxi service and get paid. You drive a limo. You drive rich people around and they pay you in cash." At 1 minute and 15 seconds in that footage, MCL states to officers, whilst in the cell, quote, "I drive a limo around as a taxi driver, so there's like a lot of customer, you know?" At 1:34, Ben states, quote, "Then say something like, 'I'm saving up to leave the city because the crime rates are crazy, because you cops can't do your effing job,' unquote." MCL once again begins to copy what Ben is saying. 2:29, Ben says, quote, "How do you know it's unmarked money?" Unquote. MCL then repeats that to Cert 184. Okay. From that body cam, we can affirm that Ben, he continues to aid and abet MCL, and MCL, instead of hanging up and calling another lawyer, chooses to go along with and engage in this fabricated story. He does not attempt to get legal representation in any which way. Continuing on, I would like to point your attention to Exhibit H, vehicle interception, at approximately 21 seconds.
Mm-hmm.
So, just after that timestamp, you can see you can see Jungle MCL open up a tablet. At the top of the screen, there are 5 icons, which appear to be tiers of some sort. D class, B class, A class, S class. Okay. 4 out of 5 tiers are marked with a green tick. The tablet has a section called Active Boosting Contract.
Objection, Your Honour.
The walk around.
Assessed by Melbourne Police and identified as an item of illegal activity.
I've not yet stated it's an illegal act.
The item was not seized off my client to be assessed. How is it?
Mr. Foster, I want objections based on legal relevance, not based on theories and arguments. If you have arguments, you're more than welcome to rebut it when it is your turn. You may continue.
The tablet has a section called Active Boosting Contract. The active contract, it states below, Vehicle Ocelot F620 Boosting Contract. B class vehicle. Time remaining 1 hour 25 minutes. Reward $55,826 and 116 S coin. Boosting contract started. Deliver it to the dealer until the contract's valid. Below the already active contract, there are 3 available boosting contracts, showing the vehicle description in addition to a green oval shaped box on the right called Accept Contract. This tablet aligns with the boosting tablet found on Jungle MCL's person during the search of his person. Melbourne Police knows of no business or practice that uses tablets like this to source vehicles, and certainly not to deliver vehicles to dealers for a reward. We would like to note that this, in combination with the tools found on MCL's person, plus the large quantity of unaccounted money found on MCL's person, creates reasonable suspicion for any officer. Now, Melbourne police officers hold the authority to conduct traffic stops on persons if they wish, and especially if there is a suspicion or knowledge that the individual has committed an offence under Melbourne law. This same policy applies to officers having the authority to detain and arrest people based upon suspicion, knowledge, or proof of the individual having committed an offence. In this case, the traffic stop itself was lawful, and the search was lawful. We can confirm that Jungle MCL was found with a contract tablet, boosting tablet, lockpicks, electronic devices, and an angle grinder. We can confirm that MCL has admitted to the $807,041 being unclean and dirty that was in the body cam footage. We can also confirm that within this trial, he has changed his story multiple times regarding that. He finally admitted it was dirty money after being called out. We can confirm that MCL was engaged in an active boosting contract at the time of the traffic stop. The procedure taken by Melbourne Police to seize these items, the cash, was lawful and proper. It was and still is a lawful seizure of funds. The access items, the electronic devices, the lockpicks and angle grinder located on MCL's person are suspicious by themselves, but in conjunction with the large amount of funds, an active boosting contract and other electronic devices creates more than enough reasonable suspicion for any officer to seize those funds, or items for that matter. The funds being seized was a lawful act, as those funds were believed to be in relation to criminal activity. Cert 184 conducted a lawful search and lawfully seized cash based upon the suspicious findings and circumstances. Given the post-arrest circumstances, specifically relating to the community service sentence after a not guilty plea was given by MCL, Melbourne Police understand that there are grounds for somewhat a civil remedy. We acknowledge that there is a misstep in procedure at the end of one of the body cams. Sorry. No, this does not represent Melbourne Police as a whole, and we do not support the policy at that body cam. But this should not result in a settlement anywhere close to what the plaintiffs are asking for. A return of the funds, which were deemed to be suspicious after the aforementioned circumstances. We are prepared to offer a settlement of $200,000 given the 30 community service, the time served, and the misstep in procedure. We are prepared to give this to the plaintiff. The demand that they are asking for is ridiculous. They're not going to be dishing out over $1 million for 30 community service. As stated, Melbourne Police understands the grounds for civil remedy in relation to the aforementioned points, and we are prepared to offer a reasonable settlement of $200,000. That is all.
Very well. We'll now move on
A legal
to...
argument, Your Honor.
Pardon?
A legal argument?
Well, you have the opportunity to do that right now. Look at that. We'll move on to closing statements now. The defense can please the plaintiffs can please come forward and deliver a closing statement. Any other legal arguments you need to make to the court surrounding the entirety of your case.
I was going to point out a statement regarding the alleged boosting tablet and contract tablet that the defense stated was in possession of my client. At no point was neither of those items were removed for examination by Melbourne Police. It simply could have been Your Honor, it could have been a video game that my client could have been playing. There's no way to tell that that was linked to the real world. There's no way to tell that my client goes around and steals cars for a living. There's so much doubt regarding the one look we got at a tablet to say that what it was. my client simply could have been playing a video game, and the first thing he opened when he opened his tablet that was in his possession was a game that he was playing.
Objection, mischaracterization. The defense has not once stated he was stealing cars. The plaintiff has stated that.
Noted. You may continue.
That was my statement.
Very well. You may continue with your closing statement and any other final remarks.
All right. The charge of dangerous driving without causing injury must not be prosecuted and simply cannot be. The standard of dangerousness has simply just not been met. A simple incident that my client was driving, attempted a lane change, looked in his mirrors, and simply might not have looked long enough and missed a police car approaching him in the distance. But what we do have, Your Honor, is a vehicle collision caused by a police car due to their dangerous driving by flying through two sets of red traffic lights going at 238 kilometers per hour around a blind spot and a blind hill in an unmarked police car with minimal lighting at night time. It's a moment of imperfect driving from my client and Melbourne Police, it is a moment of imperfect driving from my client and extremely dangerous driving from Melbourne Police in unfortunate, imperfect conditions. It's not criminal behaviour by my client. The book should be turned on the police. Like they said, quote, let's throw the book at him. Melbourne Police should be the ones facing the allegations of dangerous driving. Further, the arrest was flawed before it even began. My client's $807,041 was seized without any verification. But when my client questioned police, he was given the responses of, we're not going through this, and I've been around a very long time. That is not a legal standard. It is not a legal standard that should continue in this state. That is outright ignorance and somebody walking around with a badge willingly wanting to damage people's lives and reputation like he has done to my client. Melbourne Police tried to coerce my client with comments like, you're lucky we didn't hit you with more charges, and threatened further charges. However, no charges were ever laid apart from the dangerous driving charge. That is improper and bullying a person in an already intimidating environment that is in police custody. My client called a friend while he was in a very intimidating environment and he was scared. His friend simply helped him spit out the words he was trying so hard to say. His friend was simply helping him in good faith, and my client may have messed up with a few words because in an intimidating environment, not everything is going to come out smooth, Your Honor. You're going to be shaking. And you might say things you don't actually mean because you are scared. That is such a reasonable thing to expect from somebody that is in police custody. There's no way you expect an offender to go into a police cell surrounded by police in a station, locked in a tight area, and expect them to be at 100% of their mental capacity. My client was distraught. Police threatening him, saying, let's throw the book at him. And he's just been involved in a collision. No ambulance was requested at any time. My client was coerced, he was bullied, and he was treated like he wasn't human. The plaintiff submits that the driving by Mr. MCL was nowhere near dangerous. You cannot characterize my client's driving for not looking through a mirror for long enough as dangerous. Why don't we go arrest everybody for dangerous driving? The arrest was unlawful and incomplete, and the seizure of money was without basis. If we start convicting based on assumptions and not proof, then today my client is guilty. Tomorrow you will be guilty. Next week it will be your family member. And in 2 weeks' time, it will be your next door neighbor who is guilty. Your Honor, when doubt exists, the law can only have one single verdict: not guilty. My client, Mr. Jungle MCL, is not guilty. Thank you, Your Honor.
All right, can the defense please come forward and deliver a closing statement in relation to the entire case?
Your Honor, we have now heard the evidence, seen the traffic incident that initiated the entire situation, a reckless act that placed lives at risk. Look over the facts surrounding the arrest, the behaviour during the stop, and the items discovered on Mr. MCL's person. The plaintiff would have this court believe that Mr. MCL is a victim here. But the real issue is that Mr. MCL committed a dangerous act on our roads. He was lawfully stopped and was found in possession of tools, access items illegal under Melbourne law, and devices linked with criminal activity. The officers did their job. They had reasonable suspicion. The seizure of the money was not random. It was supported by...
Your Honor.
It's close.
There are no objections during closing statements, Mr. Foster.
The seizure of the money was not random. It was supported by facts and evidence. Mr. MCL has lied multiple times on the stand today. It is not a matter of I cannot recall or I don't know. MCL has given answers which have changed consistently. These answers have changed in order to benefit himself. I'm aware that the courts have noted these changes in answers, and the defense asks that you consider MCL's unreliable and untruthful manner here today. The law is clear. Probable cause supports arrest. Reasonable suspicion supports seizure. Both were present in this case. The defense asked the court to uphold this arrest as lawful. As stated, the defense does indeed recognise a procedural mistake on behalf of Melbourne Police. However, the civil remedy for this mistake should not amount anywhere close to over $1 million. Melbourne Police are offering $200,000 in civil remedy to Jungle MCL for this incident. We believe that is reasonable and just. Thank you.
Just a quick question on your proposal, just for the sake of the court's consideration. You still want the criminal penalties to still stand, is that correct, Mr. Jackson?
Apologies. Yes, Your Honour.
So just for my complete understanding, is I do take this into consideration upon any civil remedy that I do believe to be determined. It is $200,000 to Mr. John MCL for, I believe it was the just specifically what aspect, just for my records.
It was in relation to a procedural mistake at the end of one of the body cam footage.
Very well. So that's more towards emotional effect, so to speak, if I'm coming from it that way.
Yes. Given, of course, the criminal appeal, we are still hoping that the arrest and the charge be upheld due to these circumstances.
No worries. Court will enter into a brief period of recess until such time for judgment and verdict. Mr. Zaris, do you oh, that's not Mr. Zaris. Mr. Zaris, do you perchance have any food or water items on yourself?
Your Honor, I do have those combo boxes.
And how much do I owe in?
Don't worry about it.
No. I'll just take one, the rest you keep for yourself. No.
Very well done, Chai. That was really good.
Movement on mark. Movement on mark. That hasn't been communicated. Mark, shield up, please, mate.
Oh, sorry, my voice box was snapped. Yeah. Yeah, that's brilliant, mate. Who do you think organised the security detail? Hardy, mate. I'm loving the safety glasses. Yeah. That's no good, eh? Yeah, mate. I would. Juries are always. Want to talk about Mr. Stone's case?
Sorry. Oh, the door at the back there. Yeah.
Have you shined your shoe?
Mm. would be nice.
What is happening here? What?
Just keeping limber, Your Honor.
Stretching session, sir.
Given the time of this case, Your Honor.
That is very
that
reasonable.
was,
That is absolutely reasonable. This court case might have just been the most challenging and most complex in a few areas in the city of Melbourne ever since probably back to the Stone case. However, I do believe I've come to both a verdict for both the criminal appeal and to the civil trial, with the schedule of remedies to be paid out to respective parties. But before we get to it, I do want to touch on some brief points. Firstly, in relation to the witness statements, I found that none of the statements that were presented offered true clarity on the subject matter and did not take most statements into consideration for this verdict, relying on other evidence and oral arguments to come to my decision. I will touch base on this at the very end. Melbourne Police acted in accordance with both the Traffic Act of 2025 and their respective policies on the grounds that the police car in question did indeed have their lights on and was acting in a sane enough manner in the court's perspective. The defence was acting reckless, from swerving lanes before the incident and being on the phone at the time of the incident, and the court finds that the charge is more than valid and it is upheld in this aspect. The defendant was looking at the incoming police car and did have a brief last-second opportunity, and according to the very fundamental legal principle of the last chance doctrine, he could have prevented the incident from occurring. Upon any arrest, a search of the individual and their car is warranted to uncover any prohibited weapons and or items. Melbourne Police may quote-unquote throw the book, end quote, and base their prior experience as grounds for what they did, assuming that the end actions they participated in were legal. And in this case, I do deem it to be legal to a certain extent, albeit the manner and tone in which they communicate this aspect can be morally ambiguous given the circumstances. Upon the review of all evidence submitted by the defence, particularly of the body cam and the individual in police custody, I do find it to be deeply disturbing. Whilst at the time of the arrest, I would probably deem there to be insufficient grounds to seize such items, given the new evidence that has been submitted through the form of an individual coercing the individual to say certain things to officers, I do now find there to be reasonable grounds to prohibit the return of the dirty funds back to the individual. In my final ruling, A, the individual still found guilty of the charge of dangerous driving without causing injury, B, the funds that were seized by Melbourne Police are not to be returned, and C, a civil remedy of the following will be imposed as per proposed by the defence. A, $200,000 to be directly returned to Mr. Jungle MCL directly. 2, $250,000 to Mr. Foster for legal fees. And the third, $125,000 to Mr. Foster for legal fees to be paid up by the Department of Justice in the form of legal aid, totaling $375,000 in the form of legal fees to return to Mr. Foster, of which $250,000 will be paid by Melbourne Police and $125,000 to be paid by the Melbourne Department of Justice in accordance with our schedule of payments. And then finally, the $20,000 aforementioned directly to Mr. Jungle directly as a form of compensation as proposed by Mr. Mark Jackson. And that is all for this matter.
Your Honor, can we also have a agreement signed by all parties that this is a final settlement in this matter? Potentially a non-disclosure if that's applicable.
Unfortunately, a non-disclosure will not be possible given the open court setting this evening.
Yes, understood.
Well, I have a big ass spider. I think I'm out to refly. Wait, can I refly?